Let's cover Oregon and New York in one fell swoop. Let's talk about it. What's up, Wolverines, and welcome back to the channel. Remember, you can always go to thegundies.com and vote for me, John Crump, for top voices of the 2A. Even though I have no real chance of winning, it would be really nice just to get your vote. Okay. Please like, comment, and subscribe. Let me know what you think about these two cases down below. Both cases have to do with GOA, which is my favorite gun rights organization. So let's go ahead and start out in Oregon. If you don't know, GOA sued over ballot measure 114, which was a ballot measure put on the ballot by anti-gunners, and it passed by a razor-thin margin. The new law did a couple different things. First, it required a permit to buy a firearm. You had to do training and a bunch of unconstitutional things. It also limited the size of the magazines that you can own. Standard capacity magazines were banned. Any magazine holding more than 10 rounds was banned, which the state incorrectly called high capacity magazines. It also eliminated the transfer after 3 days if a FFL didn't get word back whether it was approved or not. If you don't know, federal law says after 3 days, if an FFL doesn't get approval to transfer the firearm, they can go ahead and transfer the firearm. Anti-gunners call this the Charleston loophole because, of course, they have to tie it to a crime committed by a maniac in Charleston. Not going to go too much into that. Just know that they are using scary languages. A judge in Harney County issued a temporary restraining order and a preliminary injunction against the law until the court can hear the full case. The Supreme Court, the state Supreme Court that is, decided not to intervene and let the temporary restraining order stand. So the state went back into state court and asked a Harney County judge to separate the background transfer out so they could get rid of the 3-day period after which an FFL can transfer the firearm. Basically, they want the FFL to not transfer the firearm until they get an answer back, no matter how long it is. Well, a Harney County judge has decided not to separate that part out of the law, and he is still blocking the whole entire new law from going into effect, which is really good because it shows you cannot throw spaghetti at the wall and see what sticks. This is good news because it shows that the judge will rule on ballot measure 114 in its entirety, and GOA has a good chance of succeeding. In fact, in order to get a preliminary injunction, one of the requirements is the likelihood to succeed on the merits of the case. So hopefully the judge rules soon, and hopefully we will know something in the next month or so. All right, now let's go ahead and jump over to New York. New York did get their response and just under the wire. I think the response came in around 3:50 and the deadline was 4 o'clock. So they did get their decision and under the wire. So let's talk about what they said to the Supreme Court. I'm going to link the complete document down below in case you want to read it. And if you want me to break down the whole thing, I will. It is kind of long and there's a bunch of dribble in it. But let me go ahead and hit on a few of the key points that New York made. The first reason why they think the Supreme Court should not overturn the stay issued by the Circuit Court is that the Supreme Court is not likely to review the forthcoming decision from the Court of Appeals, which I think is BS, because I think that the Supreme Court will have to review it because the CCIA is totally unconstitutional. The CCIA is New York's Concealed Carry Improvement Act, which added a bunch of sensitive places, restrictive places, licensing requirements, social media requirements, and about every other anti-gun thing you can think of, including replacing the proper cause, which was knocked down in Bruin, with the good moral character, which is basically the same thing, it's just a different name. Another thing that they said is that GOA did not prove that the circuit court erred in their decision in granting the stay. And I totally disagree with that. And if you read GOA's arguments, you can see exactly how the circuit court erred in its stay. It didn't give any reasoned response as to why it was issuing the stay. It just issued the stay. New York also claims that it is likely to secede on the merits of the case, which is the exact opposite of what the district judge found. And I don't think that they are likely to secede on the merits of the case, because the CCIA is clearly unconstitutional. There is nothing in the CCIA that is constitutional. It not only violates the Second Amendment, but it also violates your First Amendment. And also, New York says that the plaintiffs are not suffering irreparable harm. I think anytime a right is delayed or denied, that is irreparable harm. And your rights are being delayed or denied in the CCIA, your First Amendment right and your Second Amendment right. You can't tell me stripping someone of their God-given, constitutionally protected rights is not irreparable harm. I have no idea what New York is smoking, but I don't want any. All right, guys, hope that cleared a few things up for you. I have another video dropping today at 3 p.m., but I cannot talk about it right now because it's hush hush. Look to North Dakota. There might be something dropping up there. Okay, guys, stay ever vigilant, stay ever free. Keep in the fight. I am out of here. Wolverine's mother